Welcome to another episode of Judge for Yourself. Some argue that the country may be facing some form of constitutional crisis. Certainly, as I read certain of the commentators, the President and the Public Protector have gone head-to-head over Nkandla in her investigation of the 250 million rand upgrade of the President's home. She found that the President should pay back some portion of the money. But President Zuma says it's now up to the Police Minister to determine whether he's liable. The Public Protector disagrees. This has sparked a series of letters between the Presidency and the Public Protector's office. And there's quite a lot of debate within the newspapers as to whether the Public Protector has exceeded her powers, or on the other hand, the President is in fact wrong. Now, in order to debate this particular issue, we have in the studio with us the Deputy Minister of Justice, John Jeffrey. We have Lawson Naidoo from the Council for the Advancement of the South African Constitution. And in Johannesburg, we actually have the Public Protector, Thuli Madonsela. So let's start with you, Lawson, because to some extent you triggered my sense of the controversy here, in that you wrote an article together with Professor Richard Calland which suggested there may well be a constitutional crisis because the President has not responded adequately to the Public Protector.
Indeed, we have, Dennis, and I think we're suggesting that a constitutional crisis may be upon us, depending on how Parliament...
Very strong words, if you don't mind me saying so.
Well, it is. I mean, if organs of state are at loggerheads about their respective capacities under our constitutional democracy, then we will have a constitutional crisis that will probably need to be determined by the courts at the end of the day, because there is a lot of disagreement of the powers of the Public Protector, the role of Parliament, and how the President ought to be accountable for his actions.
Well, what is it that, in your view, I mean, I don't read the whole article, but what is, in your view, if you can encapsulate it, that you think would justify your fairly serious, well, very serious claim?
Well, I think we must look at the constitutional framework and within the concept of separation of powers, and the level that we've inserted a level of additional bodies, what we call the Chapter 9 bodies, independent bodies supporting democracy, to play a very particular role to create a sense of public trust in organs of state that was non-existent under apartheid, to create a human rights culture. So not only do we have the Public Protector and the Auditor General...
Sorry to cut in, but what has the President done? Not done, that you think he should have done?
The President has not responded adequately to the report of the Public Protector, which makes a series of findings, including some quite serious findings against the President himself. For example, that he was in breach of the Executive Members' Ethics Act. And I don't think that anybody can argue that it is only the Public Protector that has jurisdiction over that act, and she has acted in accordance with that. And no other entity is able to police that piece of legislation.
Right.
She has done so, and the President has failed to respond to her finding in that regard.
Minister, how do you respond to that?
Look, I don't see a constitutional crisis by any means. The issue is, as I would see it, the findings and recommendations of the Public Protector are just that, and are not enforceable. And there's no authority in law that I know about that says they have to be followed. When the Public Protector says the Police Commissioner should be fired or must be fired, the President can't just fire the Police Commissioner.
That's a Freudian slip.
Maybe. The President can't just fire the Police Commissioner. There has to be a commission established, and when that commission is held, they don't just take the Public Protector's report and endorse it. They have to look at the matter anew. So the President is accountable to the National Assembly, which elects the President and can also remove the President. So it is correct that the matter is with Parliament.
So you're saying that the President has done nothing untoward here?
No.
Ms. Madonsela, how do you respond to that?
In terms of the law, nobody is above the law and nobody is above the Constitution. Currently, we have the Executive Members' Ethics Act, which says that after the Public Protector has investigated and taken whatever remedial action she or he deems fit, she must report to the President, and the President is the head of the Executive. Meaning whatever the Public Protector says is advice to the President and not to Parliament. Section 3, subsection 5 of the Executive Members Ethics Act says once the President has received a report of the Public Protector, he or she must submit a copy of that report together with his comments and indication of any action taken or to be taken in pursuit thereof. And the question we have to ask ourselves as a country is, has that happened?
Well,
and if it has not happened, what is the value of the law?
But let me ask you this. It appears to me that what's being argued is you produce a report, you say the President should do X, Y, Z, and that's where your role ends, as I understand the Deputy Minister saying. And that's it. And therefore, he's entitled to say thank you very much and goodbye.
May I respond, Judge?
Yes, yes, I'm interested in your response, yes.
Well, the Public Protector operates under various laws. In some instances, that may be the case, especially when we deal with the Executive Members Ethics Act. The Deputy Minister is correct that once the Public Protector has investigated and the President has done what is required by law, the Public Protector takes a back seat in terms of the Executive Members Ethics Act. In terms of the Public Protector Act, things are different because you will read the Constitution Section 182. The Public Protector has the power to investigate, report, and take appropriate remedial action. And the Public Protector Act expands that beyond investigation, you could conciliate, mediate, negotiate, advise, and do whatever is necessary to rectify the problem.
So let me ask you. So let me ask you. Sorry to interrupt you.
Then is that.
Sorry to interrupt you, but let's say in this particular case, if the recommendation is to the President, pay back X ront, is that all it is, a recommendation? If he doesn't pay it back, what then?
Well, really, if he doesn't pay back it, he has the power or the responsibility to explain himself. That's where I was saying the Deputy Minister is right, that the Public Protector must investigate and make findings. The President has a duty to then review those findings, and in terms of the Act, he must then comment.
Okay.
So this whole debate is not about forcing the President to do something irrational if he considers it irrational. It's really about the President complying with the law in terms of commenting. So what I would have expected is that the President would comment on everything that I said, including those things that he thinks are irrational, and then advise Parliament that he has reviewed this, the findings of the Public Protector and remedial action, and he has problems with this, that, and that, so that Parliament then may debate whether the problems that the President has are valid.
Okay, thank you very much. I think I've got the framing. I'm going to come to you, Deputy Minister, but I have to take an ad break, and then we'll be back. Welcome back. So the complaint isn't so much about, let's say, reacting to remedial action, but the fact is, according to what the Public Protector said, the President is obliged to give a detailed response to the Public Protector's report, and not to say, I've read all sorts of other reports, etc., but actually to go to Parliament and say exactly how he agrees, disagrees, and why with the Public Protector, and that's, as the Public Protector is suggesting, the architecture of the Constitution.
Look, I want to refer just to the Executive Ethics Act because it was made, the finding was made in terms of that. And Section 5 specifically, and it relates more to other members of the Executive, Cabinet members, Deputy Ministers. And it's nothing in this Act may prevent or delay the appointment or the termination of the appointment of any Cabinet member, Deputy Minister or MEC. Or the amendment or determination or allocation of a portfolio in terms of the Constitution. So basically that's I think, I know the Public Protector I think was in agreement on the Executive Ethics Act, but that clearly spells out if the Public Protector makes, for example, a finding against, let's say, the Minister of Communications, as has been done, it is then, there's no constitutional crisis if the President doesn't act on that. I mean, as we know, the President did remove the then Minister of Communications. But similarly, I mean, Parliament, it's up to the National Assembly to look at the matter. That is who the President is accountable to. And the President had also referred the Nkandla matter to the Special Investigation Unit. It's a pity that in this case there seem to be conflicts or an overlap between the two. In the past, in the time of Selby Bakwa, when he was Public Protector, he would make recommendations that a particular matter should be referred to the Special Investigation Unit. And there are provisions in the Act for matters to be referred. So
she didn't do that, but the fact of the matter is that she has asked for remedial action. She's put that up in her report. Now, sure, all the question is, if Parliament is the body which the citizenry looks to hold everybody accountable, then surely the argument must be that the President comes along and says, I agree with X, I don't agree with Y, I'm not going to do Y, I'm not going to do X, doesn't muddle up a whole lot of other reports and sort of folds it all into one. I think that's the complaint.
But the President has responded. I mean, I'm not sure where the issue comes in about the detail that the President must respond, which seems to be the issue. I'm not sure what the authority is for that.
Well, I think, the President has responded to a certain extent. For example, take the issue of pay back the money. Advocate Madonsela recommended that the amount to be paid back should be determined.
But hasn't he said that's up to the police minister?
But that's the point I'm coming to, is that Advocate Madonsela said the Minister of Police, in collaboration with the Treasury, must determine the amount. The President now says the Minister of Police must determine whether he must pay anything back, not just the quantum, but whether he must actually pay anything back at all. So that's fundamentally changing the recommendation or the remedial action that the Public Protector put forward.
But sorry, let me get this right so that ordinary people can understand this. The President is obliged to respond to the Public Protector, is that correct? The Public Protector puts up this report, says there are all sorts of irregularities, and in my view, the President actually owes the public a refund. That's crudely put, well, simply put, that's what the argument is. And the President says, well, whether I owe, he could say, I don't owe a refund, correct? He could say that.
He could.
So he doesn't done that. He said, I'll leave that to somebody else to decide whether I should have to pay money back.
And it calls into question the whole issue of the independence of why do we create an Office of the Public Protector as an independent institution when the President now says that the Minister of Police, someone that he appoints and serves at his pleasure, must now make that determination. It calls into question the whole idea of having an independent Office of the Public Protector, which in terms of the Constitution operates according only to the Constitution and the law, and whose decisions should not be able to be willy-nilly overruled by a member of the executive, because then it undermines that whole constitutional scheme.
Can I come in?
Well, yes, but I want to ask the Public Protector, but carry on, yes.
Okay, I think the issue is the question of are the recommendations of the Public Protector enforceable? Mr. Naidoo seems to feel that they are. I'm not sure on what authority.
Well, I'm not sure he's saying that. Is he saying that? I thought he was saying, sorry, let me get through this. I thought he was saying, as a Public Protector, you've got to respond comprehensively. I think he's dissatisfaction of the comprehensive nature.
No, as I understood his issue was that if the Public Protector says the President must pay back the money, then the President must pay back the money according to Mr. Naidoo.
And if you're going to challenge that, then you must challenge it in a court of law.
So he is saying that.
Okay. So if the President,
I'm not sure what legal authority he's then making that suggestion.
Right. Can I ask the Public Protector whether that's what she has in mind, and then we can... Ms. Madonsela, do you see it that as a result of your recommendation, he's obliged to pay back the money, or alternatively say, I'm not paying back the money? I'm trying to sort of work out for my audience what it is that on your report he'd be expected to do.
Right. Two things, Judge Davis. The first one is that the issue about recommendations, I would rather stick to the South African Constitution. I was in Estonia this week, and we discussed that each country must stick to its constitution. And there was a wide range right up to the Eastern Europe constitutional structures where they can go to the Constitutional Court if government refuses to implement. So let's stick with the South African Constitution, investigate, report, and take appropriate remedial action. And then let's come to the Executive Members Ethics Act. It says you have to investigate and report, and then the President has to comment on it. As we deal with that, we have to understand that the president is the head of the executive. Whatever happens in the executive is the president's problem, not Parliament's problem. The report that I've submitted to the president is not about the president. It's about what happened at the president's private homestead. A lot of the findings have nothing to do with the president, have to do with how his ministers acted. And the president has not addressed me or anyone on those issues. My expectation, which I think is the expectation of the Act, is that the president should apply his mind to the entire report and disagree when he disagrees. But the story doesn't end there. I still am with Mr. Naidoo that Parliament will evaluate the president's answer. Even if Parliament agreed with him, if Parliament does so wrongfully, the matter could still end up in a court of law, and the court of law would have to decide whether I was irrational in the findings that I made so as to allow the president to ignore them.
But do you accept that a president, with you're not the final determinant, and a president can say, I disagree with that, I'm sorry, she's wrong?
Well, I think that the Noma Iudex principle does not allow the president to have a final say in whether he was right or wrong. I think. But
you don't have the final say either.
Would have to. Well, I'm saying at my level, I have the final say until a higher authority has overruled me. I would agree with you.
Okay, got you. I want to debate this as well, but I must take another break. Welcome back. Before I ask the Deputy Minister, I just want to pick up something that the Public Protector said. Her finding is final until set aside by a court of law.
Absolutely.
What does that mean in practice for people watching this? What does that mean?
That's the report of the Public Protector. The findings that she makes are enforceable and should be enforced.
By whom?
And Parliament is the oversight authority, because the issue is that the Public Protector is accountable to Parliament, as we know, in terms of the Constitution. The Office of the Public Protector has no enforcement powers of its own, and therefore has to rely on the body that holds the executive to account, which is Parliament, in order to ensure that those recommendations, findings and remedial action are indeed implemented. And if there is going to be a challenge, then there must be a challenge, as the Public Protector says, to a higher body, which would be a court of law.
But forgive me for being confused now. I mean, I thought that if the Public Protector sort of issued remedial steps, the President applies his mind, in this case his mind, to, as opposed to her, to the report, and then he says, well, I agree with that, I don't agree with that, or etc. the case, and then it goes to Parliament. He doesn't have to do more than that, really.
No, but and then obviously...
Like a court order where you can execute upon it?
No, but you have to challenge the basis of that decision, the rationality of the decision.
Are you saying he can't say to Parliament, I'm sorry, I think there's a lot of codswallop for the following reasons?
He can indeed do that, but then he must also take that argument to the courts and have the report of the Public Protector reviewed by the courts.
Are you saying that Parliament is then obliged, let me get this right, on the basis that he doesn't, I don't quite know, I mean, in other words, what I'm trying to ask is, when he says X, Y, Z, and as for the money, let the police minister decide that, who then seeks to enforce that? Because your argument is until he set it aside, it seems to be binding.
Well, it's Parliament's duty, I would argue, to ensure that the findings and remedial action is indeed implemented.
And what happens if Parliament thinks that the remedial action and the findings are incorrect?
Then it must be taken on review to a body that has authority.
Not Parliament itself,
which is a court.
But I thought that the Public Protector was answerable to Parliament.
She is answerable to Parliament in terms of the functioning of her office, in terms of its use of the budget, etc. Of course, she has to be accountable to Parliament for that. But the independent nature of her office would mean that her decisions have got to be outside of the realm of party political debate.
Minister, I mean, essentially what is being suggested is that if you don't like it, then set it aside.
Look, Judge, with respect to Mr. Naidoo, I mean, I totally disagree with him. and it's been shown.
What has been shown?
Well, that he's not correct.
Why?
I mean, for example, the public protector, a previous one, made a finding against the then Minister of Minerals and Energy, Penwell Maduna. That report was referred. He, I think, made critical comments about the Auditor General. That matter was referred to the National Assembly. The National Assembly then implemented some of the recommendations, but didn't agree on everything. There's no way that, I mean, I also disagree with the assertion that it's the final say until a higher authority or a court reviews it. The public protector is an ombudsman. Ombudsmen make recommendations. They're put into the public domain for moral persuasion, for the public to look at them and to understand that this is what the public protector or the ombud has said. There's no way that the public, if they become enforceable...
What is the point of the public protector then? And surely the whole act was to design, the Constitution Section 182 was designed to
They
give
are
the
an
public...
ombud, and as other countries have ombuds, they're an ombud. They're there to investigate a matter and to put it in the public domain. They have moral persuasion. They're not enforceable. Otherwise, no, let me just finish this point. Otherwise, if the public protector's orders were enforceable, why would you need to go to court, the Labour Court or courts to review administrative action, if all you've got to do is go to the public protector, convince the public protector that you're right, and then you have an enforceable order?
But what does it mean, remedial action, then? What does remedial action mean? That meant action.
Well, action
she said, please remedy what
yes,
I have found.
But as I said, in the case of the Commission of Police, where the public protector's remedial action is that the commissioner must be fired, that matter can't just be acted upon. That matter has to follow a process set out in the law. There are often complaints to the public protector about the Master of the High Court and the appointment of executors. Now, the normal process is if there's a dispute, those matters have to go on review. You can take a matter to the public protector. The public protector has wide powers, but you can't then go to instead of taking the matter on review, go to the public protector, get the public protector to agree that the wrong person was appointed as executor, and voila, you've got an order.
Let me ask the public protector. It seems to me that the criticism here, Advocate Madonsela, is that you're acting like a court, and that you're not, that you can make recommendations, but that's where it ends. Any enforcement has to be done by an action in a court.
Can I just firstly dispel that myth? Can I start by dispelling that myth, that it is not true that the only institutions that make binding findings are courts. The CCMA makes binding findings, the Electoral Commission makes binding findings about elections, a Competition Commission. So it's not true that you must be a court of law to make binding findings. Secondly, regarding the enforcement of public protector decisions, which would be findings and the remedial action he or she takes, it's not enforceable in the manner in which court decisions are enforced, but that doesn't mean it's not enforceable. The parliamentary process is a process that can be invoked by the public protector himself or herself or by Parliament to call whoever is refusing to implement to come and explain themselves. But beyond that, complainants can take the matter to court to enforce it. Also, it's been said,
you're saying, sorry, let me get,
there's nothing that stops me as the public protector from taking the matter to court.
Well, all right, but what I'm asking you is, are you saying,
unreasonable?
If Parliament says, we've read the report, we've seen your remedial action, we're not satisfied with it, well, then why should that not be the end of the matter?
Because we're not a parliamentary ombudsman, and the deputy minister, with due respect, I have copies of the statute from Sweden here, from Denmark and England. Each public protector or ombudsman has different powers. The first thing the deputy minister needs to know and other people need to know is that the Swedish ombudsman and many other ombudsmen are what you refer to as parliamentary ombudsmen. Two, the Swedish ombudsman, the reason you can't review its decisions is because it's the ultimate body. The Swedish ombudsman, for example, can review your decision as a judge. insofar as the procedures and your adherence to the principle of fairness may be concerned. Again, that is because of the Swedish statutes.
So
in
to
South
whom are
Africa,
you-
we are a
so to whom are
constitutional
you-
ombudsman. My decisions are subject only to the Constitution and the law, meaning only a court of law may then review and send back if I was irrational in making that decision.
So are you saying that if you say to the president, you pay back the money, the president must pay back the money, unless it's set aside by a court of law?
Well, I'm saying two things, Judge Davis. The first one is that the president has to apply his mind and indicate that he doesn't really think that he should pay back. He didn't act unethically as suggested in the report. There was no omission in 2009 when the matter went to the media and things like that. The ministers did not act improperly. He would have to say that and then say the public protector was irrational in arriving at these conclusions. No reasonable public protector would have done the same. Parliament would then review, but Parliament cannot review my findings, but it can look at the remedial action. It can look at the president's defense and look at whether the president is more rational than myself.
Okay. So have we created a public protector who's above everything then?
It's not, the Office of the Public Protector operates within the Constitution and is subject to the Constitution and the law, which is enforced by the courts more than anything else. And I think the point is that if the Public Protector is going to exercise functions without fear, favour or prejudice, and the SCA mentioned this in the Mail and Guardian case, that those words are not just rhetoric. They have to have actual meaning, and that meaning has got to translate into the independence of that office.
So the final point, I just want to ask you this. I mean, many people would say, I mean, are you serious? You're asking the Minister of Police, who's basically under you, to do this. Why isn't this done properly by the President making an authoritative statement himself?
Look, that matter is with Parliament, and that's also up to the President. But the issue is, I mean, the decisions can't be enforceable. As the Public Protector herself said, she could go to court and make them enforceable.
Yes, correct.
In some jurisdictions,
may be able to do that
in some jurisdictions, the specific provision for that to happen, but not in ours, although presumably it could happen. But that's an indication that the findings are not enforceable.
All right. Unfortunately, I've run out of time. As much as I really would like to say, I'm sorry. I've tried to give everybody as much time as I could possibly. This is a particularly interesting question. The question of Nkandla doesn't seem to ever end, but on this particular question, it really relates to a very narrow and yet important issue. What is the role of the Public Protector? Well, how enforceable are the decisions she takes? To whom is she accountable? And has the President in this particular case followed the Constitution as he should do? Is he correct in his interpretation? Is the Public Protector, is Mr. Naidoo, correct in his? You've got quite a lot of the argument. You can judge for yourself. Goodbye.